All right, let's talk now about the other case, Wyeth against Levine, which was the implied preemption case about prescription drugs. Let me just start by saying a little bit about the facts. Diana Levine is a popular Vermont folk singer. She was given 2 injections of Demerol and the anti-nausea drug Phenergan for migraine headache in April 2000. The first injection was intramuscular, that is into her muscles. The second injection was intravenous, using what's called the IV push method. That's as opposed to injection through an IV drip. With an IV push, you actually use positive pressure to push the medicine into the veins. Now, it has long been known that Phenergan, if it comes into contact with arterial blood, causes tissue necrosis and gangrene and can require amputation of the affected limb. And that, unfortunately, is what happened in Diana Levine's case. Ultimately, her hand and her forearm had to be amputated, and she lost the ability to play the guitar. She settled with the clinician and the clinic, but then she sued Wyeth, the manufacturer of Phenergan, in state court for negligence and for failure to warn. The jury was instructed that it could consider the FDA's approval of Phenergan's labeling, but that FDA approval does not establish the adequacy of the labeling under state law. And the jury found for Levine and awarded her $6.8 million. The Vermont Supreme Court affirmed over a dissent by its Chief Justice, and the U.S. Supreme Court granted Wyeth's cert petition. So the issue, as the case came to the Supreme Court, was whether Levine's state law claims, based on the theory that Phenergan's labeling should have been different, are preempted by federal law. The court held that there is no preemption by a vote of 6-3. And what I'll do, I'll just briefly describe the court's decision. I'll briefly describe the dissent. I'll say a few things, and then probably my 10 minutes will have expired. The kinds of preemption that were at issue in this case, we got the quick tour through the versions of preemption, so I can skip that. We're talking about conflict preemption here, and both types, that is the physical impossibility to comply with both federal and state law, and the other type, the so-called obstacle preemption, or Hines against Davidowitz preemption, where the state law is an obstacle to achieving the purposes of the federal law. Both of those were raised by Wyeth, and both were rejected by the majority. As to impossibility, the argument there was that a regulation of the FDA really would not allow changes to the labeling without FDA approval. The FDA initially approves the labeling word for word and comma for comma, so it's really a question of then can you make changes after the initial labeling is approved by the FDA. The argument that Wyeth made, which was actually supported by the FDA, the Solicitor General was on Wyeth's side in this case, was that their labeling, called the CBE regulation, the regulation about these changes, CBE stands for changes being affected, would allow unilateral changes without the prior approval of the FDA only if there's some sort of new information that would justify that change. And the majority of the Supreme Court disagreed and said, really, we think the regulation allows unilateral changes for, it could include new analyses of existing information. It could include just accumulation of more examples of bad results. The court said that really the manufacturer bears responsibility for the content of its label at all times. That's a quote from the majority opinion. It said the FDA really has never gone after a manufacturer for unilaterally putting stronger warnings on its label without getting prior approval from the FDA. Now the court did leave some room for preemption here. It said, absent, again I'm quoting, absent clear evidence that FDA would not have approved a change to the label, the court would not conclude that it was impossible to comply with both federal and state law. And interestingly, the majority said the lower courts found as a matter of fact that FDA might have approved a labeling change. So the court viewed it as a factual issue whether the FDA would have approved a stronger warning. So that was impossibility preemption. The majority said there wasn't any. On obstacle preemption, the argument that Wyeth and the Solicitor General made there is the federal regulation really doesn't just set a kind of floor for safety, which then states can raise if they want to have more safety, but actually strikes a balance between the safety of the drug and the benefits of the drug, and tries to figure out what's the optimum balance of warnings that will get the drug to the people who can benefit from it, but keep it from the people who would be harmed. And the majority didn't agree with that argument. They said there's really no evidence that Congress intended to preempt state law claims of this kind. Congress was aware that these types of claims were brought. It didn't have an express preemption clause, unlike the Medtronic case against Regal. And it pointed out there really is no federal remedy for persons who are injured by an FDA-approved prescription drug. So if the state law is preempted, the plaintiffs really are left without any remedy. And the majority also gave the FDA's views very little weight. It pointed out that the FDA had recently changed its position, did not provide an opportunity for notice and comment, and also said pretty expressly that the FDA's resources appear to be limited, and they may not really be able to do this on their own. There was a concurrence by Justice Breyer, who has an administrative law background, as many of you may know, and he said he thought the FDA does have some power to preempt state law if it wants to by promulgating notice and comment regulations. Justice Thomas, this is, maybe for another symposium, he had an interesting opinion saying he doesn't think this sort of Hines against Davidowitz preemption ought to ever be allowed, the obstacle type of preemption. Although he said if there was a logical contradiction between the state law and the federal law, along the lines that federal law gives a right and then state law takes that away, it'd be physically possible, obviously, to comply with both, but that would be a logical contradiction. Let me go even quicker through the dissent, because the dissent got only 3 votes. Basically, the dissenters agreed with the arguments of Wyeth and of the Solicitor General, and said the FDA does make a safety determination, does strike a balance. The state really shouldn't alter that balance. If we had more time, I should have probably started by saying I was on the losing side of the case. Those of us who got deep into this feel that the majority has played fast and loose with the facts. And if you want to, we can go into that, but I will skip that at this point in the interest of time. And also, the senators thought the court really was not following its prior decisions, which is Geyer v. Common Motor, and pointed out again that the point that juries really are not very well equipped to make this overall balancing determination, because they had one patient who was having a bad outcome, and obviously one can't take the bigger perspective and apply the scientific knowledge to the decision. So very quickly, what are the explanations for the result and what will happen next? I mean, I do think it was a very sympathetic plaintiff. I mean, really just a tragic outcome. I do think the tide, to some extent, is running against implied preemption. So that was an important difference. Obviously, a number of justices shifted when it became a question of implied rather than express preemption. But I'd also say, these types of state claims had been allowed for decades. They're becoming much more common recently. You could even say they've exploded, but they had been allowed for a long time. There is no federal right to compensation. I think that played a role in the thinking of some of the justices. You can see that in the opinion. The FDA had changed its position pretty recently on this, and there were doubts about the FDA's capacity to do the job on its own. Again, that was said right in the opinion. And there were also, we'd had an election, there were prospects of legislative overruling, and I think that could have factored into some of the justices' thinking. So what will happen next? I mean, there is, as I mentioned, there is room for some preemption after the court's decision if there's clear evidence that FDA would not have approved a change in labeling. And as you mentioned, we have the Colachico case, which has gone back to the Third Circuit, and we may learn some more about that. And that appears to be a factual issue, so it could be decided by juries. It's also possible that contraindications, that is, that a drug shouldn't be used at all in a particular way or for a particular purpose. For example, there were arguments in this case by the plaintiffs that there just should never be IV push administration of this drug. It's just too dangerous for the benefits. Or indeed, there shouldn't be any IV administration at all, even by the IV drip. Those arguments were made. The court said, well, we're not really deciding whether that kind of determination would be preempted. And certainly you can make additional labeling requests to the FDA to build a factual record, and I would expect to see somewhat more of that happening to the extent the FDA says more and says it more clearly about what changes they would not have approved. Then you could have preemption under the court's decision. And the final thing I would say is, and again, I'm speaking as an advocate, you're all judges and you're used to seeing advocates in front of you. To me, there is a kind of fundamental strength to these preemption arguments that is going to cause them to tend to bubble up in some form at some future time. I mean, to me at least, it is true that the FDA does balance risks and benefits. It doesn't just set a floor. So that part of the argument, I think, is correct. To me, it is also true there is such a thing as overwarning. If you put too many warnings on the label, it's hard to tell which ones you really need to pay attention to, and you can dilute the effects of the warnings that really matter the most. And it's really true that juries ultimately are not well placed to make these overall risk-benefit determinations. And the compensation question, I think, is a serious one, but that could be addressed in a variety of different ways. Again, that may be a subject for another panel. So with that, I will stop.